Chapter 2, Ethics for IT Workers and IT Users, Part 3 of 4. Now let's look at ethical issues related to IT certification and liability. The learning outcome is to evaluate how certification and licensing affect the ethical behavior of IT professionals. Let's start with certification and ethical behavior. There are multiple certifications available to IT professionals. Those with certificates demonstrate that they have a set of skills, knowledge, and/or abilities and would be able to accomplish certain goals with your company. Which IT certification is better? It depends on your goals, company needs, professional development opportunities, etc. All certifications are good. When you possess a certificate, it indicates that you have certain prerequisite education and experience as required by the group that administers the exam. Some exams also require years of experience prior to issuing the certificate. Popular certificates include Project Management Professional, PMP, Microsoft Certified Systems Engineer, MSCE, as well as certifications relating to information security, CISSP, and many others related to specific products such as Cisco, Java, networking, etc. Get the certificates that you qualify for, that are helpful as you look for jobs, and that are interesting for you long term. Otherwise, you may shell out a lot of money with little return. If you get a chance, take a look at the YouTube videos, A Day in the Life of a CISSP, and Why PMP is Important. We've talked about how IT workers are not licensed by a government or industry group. Let's look at why they aren't. IT workers come in all shapes and sizes, from routine support to business analysis to database administration to enterprise system manager to mobile application developer to project manager to technical security specialist. That's a very small subset of what IT workers may do upon graduation. Thus, there is no agreed upon core body of knowledge that IS workers require. We can't even decide sometimes if IS resides in College of Business or with computer science, or even if a CS degree is acceptable for IS, or vice versa, or with engineering. Second, since we can't agree on the required body of knowledge for IS/IT workers, there are no general license exams like those you may take for professional engineer, PE, certified public accountant, CPA, and numerous other administrative groups that oversee auto mechanics, plumbers, electricians, etc. Finally, even if we had an agreed upon core body of knowledge, who would create and administer the exams and update the body of knowledge over time? For IS/IT workers, the answer is nobody. There isn't a group that accredits IS/IT programs and then assesses and ensures the competencies of each worker. There are options for program level and/or university level accreditation of IS-related programs. Now for IS, we do have ABET as an accrediting body. While ABET focuses on computer science and engineering accreditation, it also reviews and assesses information systems at the program level. Did you know that KSU's BBA-IS program is accredited by ABET? The Department of IS within the Coles College of Business is accredited by the Computing Accreditation Commission of ABET for the BBA information systems. KSU is one of the few BBA-IS programs to receive ABET accreditation along with accreditation by the College of Business by AACSB. AACSB and ABET have different ways to measure whether programs are meeting expectations, and it's difficult to acquire both certifications. Further, KSU has been designated as a National Center of Academic Excellence in Information Assurance and Cybersecurity Education. That designation is institution-wide and is evaluated by NSA and Homeland Security. Notice that neither designation says anything about individual levels of preparation for careers in IS, IT, and/or InfoSec. Even though the textbook says that IT workers are not professionals, they may still be held liable for their actions, as long as the following factors are considered. First, there must be negligence on the part of the IT worker. From a legal perspective, negligence refers to the actions of a person in a situation where the person did not act as a reasonable person should have acted in the same situation with the same level of knowledge and experience. This reasonable person standard will be discussed further in the next slide and throughout the semester. In addition, some harm must occur because of the negligent act. The harm may be psychological, physical, or otherwise. Telling the truth is an absolute defense to negligence, unless you agreed not to share through contract law. An IT person, or any person for that matter, may be sued or possibly arrested for committing a tort. A tort is simply an unwanted intrusion on a person that causes some sort of damage. If you hit someone, for instance, you may be charged with assault. If instead you post information that damages a political candidate and you knew what you posted was untrue, then you may be sued for defamation and the person may request monetary damages. This is why newspapers and other reporting sources typically need more than one source before publishing a story. If you argue that what you posted is clearly your opinion and you believe it to be true, then your behavior would be compared to a reasonable person in that standard. With all the political information and misinformation online, there's a lot of opinion backed by very few facts. This is true of both sides of the political spectrum, unfortunately. That's why you shouldn't read only those websites with whom you agree, but read from diverse sources. You think it's fake news? Do some research. The New York Times allegedly leans liberal, while the Wall Street Journal allegedly leans conservative. They both are respected journalism sources, so take a look at how both of them interpret the same information. You may also go to Snopes.com, which debunks false information. The point is to obtain a diverse interpretation of what is happening before forming an opinion on the veracity of news. If you think it's fake news, back it up with reliable sources from diverse publishers. If you think it's correctly reported, back it up with reliable sources from diverse publishers. Backing up your sources should be something that you do when you gather research for your paper. Where do sources agree and where do they disagree? Where do they report inconsistent information and what have others said on the subject? Again, use diverse resources before forming an opinion. When evaluating whether someone acted reasonably, courts and juries examine the duty of care. Did you have a higher responsibility to protect someone over others? Does that responsibility rise to the level of a fiduciary duty? What in the heck does fiduciary mean anyway? If you have a fiduciary responsibility, you have a higher level of responsibility. It's most clearly identified as a parent and their children. If there is a fire in my house, I should go back and get my child, even at great danger to myself. I owe my child a higher duty of care. If instead you walk by and see my child in a blazing fire, you're not obligated legally to risk your life to save my child. If you are an off-duty firefighter, you likely should attempt to rescue my child simply by your profession. That's similar to me finding someone who is choking on food versus a nurse finding them. The nurse has a higher duty to respond to the choking stranger than I do. To prove negligence, it must be demonstrated that your failure to act as a reasonable person would have acted breaches your duty of care, and you should be punished with jail time and/or fines and/or community service. To bring this all together, IT workers should ensure that their products work or the services perform as expected. If harm results, they will be evaluated by the reasonable person or reasonable professional standard, whichever is appropriate. For instance, if it's an IT application that provides ventilation in a hospital, there must be numerous backup options. If the system suddenly reboots, it could mean loss of life. Or has anyone ever used TurboTax before? I have. Years ago, they had a small calculation error in their program. If customers received penalties and interest based on the calculation error, TurboTax paid the fees and interest. It was their error, and some harm resulted to a few people. They responded appropriately and fixed the error in question. Let's take a look at all these reasonable or unreasonable people and see when they may be held liable and under which standards. There are several different ways to assess a reasonable person who does something. We have to evaluate as if anything is wrong with what she or he did. The basic reasonable person standard evaluates a person who is objective, careful, and conscientious, and who would have acted in the same or a very similar circumstance. This is an ordinarily skilled person who is walking down the street. We talked about a nurse in the previous slide who encountered someone who was choking on food. When the nurse is evaluated by a jury of peers, which doesn't exist. It's really just those who couldn't get out of jury duty or those who want to be there. She will be held to a reasonable professional standard, which is a higher fiduciary level of responsibility than I would have as a non-medically trained observer. Similarly, how would a reasonable profession have acted when releasing TurboTax? Did they have a testing procedure in place? Was it as good or better than in industry standards? If the reasonable professional standard is violated, then professional malpractice may result. This is liability that applies to the doctor or nurse or lawyer or electrician who breaches their duty of care. They were supposed to fix your car, and instead your tires were loosened and came off while you were driving. The mechanic might then be criminally or civilly liable for any injuries resulting from that accident. That's just like TurboTax covered the penalties and fees that might have resulted to their customers who expected a tax program that can complete basic addition and subtraction tasks without problems. Let's take a look at another recent real-world case. This was Alekna versus Daytona Discount Pharmacy in 2015. Let's look at what happened. A patient was prescribed anti-anxiety drugs by his doctor. These prescriptions were filled by the pharmacist as written on valid prescriptions from doctors. However, the allegation was that the pharmacy should have known not to fill prescriptions that were unreasonable. The patient was written new prescriptions before completing the current prescription and was able to access too many drugs. The estate of the victim argued that the pharmacy should not have filled prescriptions since they were unreasonable on their face. That is, an ordinarily trained pharmacist would not have filled the prescriptions and kept refilling them early, even if the prescription itself was lawfully obtained from a medical professional. The trial court agreed that the pharmacist was just doing his or her job. The estate of the victim appealed, and the appeal court decided that the lower court should have evaluated whether the pharmacy owed a legal duty to the victim, a fiduciary responsibility that might support the claim of negligence. The appeals court says that pharmacists had a higher level of care when they filled prescriptions and could not simply fill all prescriptions that were written by licensed doctors. Instead, the pharmacy should evaluate how reasonable it was to refill the prescription so early and in such high doses The appeals court determined that the prescriptions were unreasonable on their face and that a reasonable pharmacist, referring to the reasonable professional standard, would have followed up with the doctor or at least warned the patient that complications might result. Thus, the case was sent back to the lower court to determine if the pharmacy was negligent. Let's look at another case, this one involving a breach of the duty of care of a reasonable professional, Vuono v. New York Blood Center. Mr. Vuono was hospitalized for heart bypass surgery. He received an infusion of blood which was contaminated. Because of the contamination, he could not receive his heart surgery. It was agreed that the contaminated vial was processed by New York Blood Center, who he sued. Looking at an overview of the case, we can ascertain that Vuono followed standard operating procedures for processing the blood they then provided to the hospital. The glass vial, which Wheaton manufactures, had a small crack of opening in it. If you held the glass vial up and visually checked each vial, you could see the flaw. The flaw caused the integrity of the sealed vial to be compromised and contaminated the blood. New York Blood Center asked the lower court for summary judgment, which means that we all agree on the facts, but even if all the facts are proven, New York Blood Center would still not be negligent. The courts decided that there may be a higher responsibility to ensure the integrity of the product, higher even than the standard of care of the entire industry. In fact, the practice of the industry as a whole may be unreasonable. Just because New York Blood Center adhered to industry standards does not prove that they were not negligent. The blood center may have a higher fiduciary responsibility given the potential health implications of its product. They may need to inspect the glass vials, even if nobody else in the industry takes that step. The standard of care in this instance is obviously very high, since a negligent act could result in severe harm to a person. Therefore, the lower court refused to issue summary judgment, and the case would proceed. To summarize, we talked about professional responsibility and the potential for poor outcomes to lead to the court system, particularly for professionals who are licensed. IT professionals must make sure to provide an appropriate level of diligence testing and retesting to minimize liability. When you're dealing with potential harm to a person, the standard of care is very high, and efforts should be taken to ensure safety. These efforts may need to be beyond the level of effort exerted by others in the same industry. The standard of care is very high when dealing with the health of a person. And even if you do follow all of the same safety steps that others in the industry follow, you may find, like New York Blood Center, that those efforts are insufficient and your organization is liable.